Good morning. Thank you for joining us for our Data Practices Security and Breaches webinar. As you know, the Data Practices Office is a small office in the Department of Administration, and we're a statewide resource on data practices and the open meeting law for members of the public and government. We perform a variety of functions listed here. It is the end of March 2023 when we're recording this webinar, and the legislature is in session. We're tracking legislation, and you can sign up for our listserv and receive a summary of changes in our July FYI newsletter. This PowerPoint is posted on our website where you registered for the webinar. We also record our webinars, so if you miss part of today's webinar or would like to have something repeated, this will be posted to our YouTube page in the next few days. If you would also like to download a copy of our PowerPoint right now, I'm sharing a file for you to download and save to your computer. So 1 second here while I get that transferred. Okay, so you should see a pop-up window appear on your screen. You can select the file and download it to your device. We're going to talk about some of the provisions around security in Chapter 13 and how those provisions work to help avoid data breaches. We will leave some time for questions at the end of the webinar as well. If you do submit questions, make sure you choose all panelists when you submit your questions so we can be sure to see them. There are various provisions in the Data Practices Act and administrative rules that work together to form the security requirements for the Data Practices Act. They are very general to accommodate the breadth of work that government entities do. These provisions only apply to data on individuals. That is data where a natural person is the subject of the data. So I'm primarily going to be discussing the treatment of data on individuals during today's webinar. In general, there aren't any security standards in Chapter 13 for not public data not on individuals. So that would be non-public or protected non-public data. Entities will have to make their own risk assessments as to the security needs related to data that's not on individuals. As a practical matter, the same policies and practices that government entities apply to not public data on individuals could also be applied to not public data on individuals. It is just not explicitly required by the Data Practices Act. So an important part of providing access and protecting data on individuals is knowing what entities can collect. Section 13.05, subdivision 3, which is listed for you at the top of this slide, includes a limitation on the collection of data on individuals. So when government is developing programs, drafting applications, and other forms, entities can only collect what they need to perform their sanctioned activities. So if your entity does not need the data to perform one of its authorized functions, then it may not collect it, even if it is public data. That's the first line of defense to avoid a data breach or other issue down the line, is not having data that you don't need about individuals in the first place. As a practical matter, the more private or confidential data that entities maintain, the more data they have to the more data that they have to administer and keep secure. So in terms of thinking about liability, each collection of private or confidential data is an opportunity for a data breach. So entities should consider carefully at each collection and whether it is actually necessary to carry out their official responsibilities. Where we often see examples of unnecessary collection is through forms or dated forms that entities have used for extended periods of time without reevaluating whether each of the fields continues to be a necessary collection of data to administer its programs. Minnesota Rules 1205.1300 contains additional requirements to review the kinds of data and records an entity maintains and to provide training and guidance to employees who interact with that data. Another limitation on the use of private or confidential data is what entities provide in their tenancy warning notices. If the entity collected the data directly from the data subject, the entity can only use the data as stated in the tenancy warning, subject to the exceptions that are listed in 13.05 subdivision 4, which include data that existed before the Data Practices Act was enacted, so before 1974, that has been treated as not public data. And if there is a law enacted after collection of that data, that allows the use or sharing. Private and confidential data may also be used in a different way than described in the tenancy warning when the government entity has asked the Commissioner of Administration for a new or different use and the Commissioner has approved. And of course, private data may be used or shared with written informed consent by the data subject. I've included the citation to the rules that contain the written informed consent requirements on this slide. Our website, we also have sample informed consent forms that you can use or adapt to your entity's specific situation. So section 13.05 also includes a couple of requirements for procedures. It's important to note here that these are different from the required access policies that are outlined in section 13.025. So this is an additional requirement imposed on government entities for these internal procedures. Entities must have procedures to ensure that all data on individuals are accurate, complete, and current for the purposes for which it was collected. Data subjects have the right to challenge the accuracy and completeness of data and to appeal entity determination to the Commissioner of Administration. If the Data Practices Office is unable to resolve the matter informally, we have to schedule that matter for a contested case proceeding at the Office of Administrative Hearings. So this requirement is in part to help ensure that entities and data subjects don't have to go that route. There is also a requirement to establish appropriate safeguards for all records containing data on individuals. Entities need procedures to ensure that private and confidential data are only available to those within the entity who have a work need, and that those employees are only accessing this private and confidential data for those required work purposes. So entities need to have a policy incorporating those procedures, which can also include information about data sharing. These policies and procedures are also cited in the data breach section of the Data Practices Act. So having them in place should help with determining if a situation rises to the level of a data breach. The final requirements of 13.05 subdivision 5, or the final requirement, is for entities to ensure they are destroying data appropriately. So entities must destroy not public data in a way that prevents its contents from being determined. And of course, another security measure is making sure that entities verify the identity of data subjects asking for their own private data or data about their minor children. Again, the requirement 13.05 subdivision 5 is to have procedures, so internal structures for security safeguards and a policy incorporating those procedures. As an example, this slide is how we accomplish that at the Department of Administration, or a portion of it. Admin's policy for ensuring the security of not public data outlines our internal procedures and security safeguards, which includes adding a column on our data inventory that documents work assignment access to not public data. Stating that we include work assignment access in employee position descriptions, so each employee knows when their position requires access to not public data. And it also includes a paragraph about sharing with other entities and when that might be appropriate. The policy also recommends some actions for ensuring appropriate access, such as limiting access to shared network drives, implementing password protections for not public electronic data, password protecting and locking computers at workstations, and securing hard copies of not public data in locked filing cabinets. I'll note where you can find a version of admin's policy of this policy on our website after I talk about the data inventory as well. So one thing I mentioned already that can help an entity understand which data are subject to the procedures for ensuring appropriate access is the data inventory. All government entities must have a data inventory that lists the types of private and confidential data that the entity maintains. For instance, all government entities have private personnel data. That should be listed on their data inventory. Inventories should be updated yearly at a minimum. The inventory needs to list the responsible authority by name, title, address. So anytime there's a change in personnel, that's another opportunity to update the inventory and, of course, your access policies. For those of you in the responsible authority or DPCO role or legal counsel advising an entity, if you're not sure if you have the data inventory or if you haven't looked at it recently, I encourage you to locate that and review it to make sure that it is up to date, that you don't need to change the contact information on there, that you don't need to add additional types of data that you're maintaining about individuals. So take a look at that if you haven't done it recently. Finally, this data inventory is public and entities must make it available to members of the public. So we have a screenshot of our website on this slide. If you navigate to our website, you can find our model policies and the procedures that I've been talking about through our resources tab at the top of the page, and then clicking on model policies. Here's where you can find examples of what we've just discussed. And then in addition to the model access policies, which I'm sure you all have, we have the policy for ensuring appropriate access to non-public data and a version of admin's inventory posted on these tabs. So you can see how we've incorporated these requirements and how we've included the appropriate safeguards piece. You can feel free to contact us or reach out if you have any questions about accessing these examples on our website, or if you can't access this page for copies. But I also want to note that the Data Practices Office isn't responsible for maintaining admin's data practices, policies, and procedures. So the department's official up-to-date policies are maintained on admin's website. We keep these versions on the Data Practices Office website for demonstration and example purposes. So here is a summary of questions that you can think about when determining what kinds of documentation and procedures are required. The first is, are the data on individuals? Are they data about living human beings? If the data are not, if they're not about a person or a living human being, they don't need to be incorporated into the policies and procedures required by 13.05. However, you can certainly choose to include data not on individuals in your policies, data inventory, and policy for ensuring the security of not public data. But ultimately, your government entity determines what security requirements around non-public and protected non-public data, not on individuals, are. If the data are data on individuals, so they are about a living human being, there are still limitations on collection and storage, as we've discussed. So government should only collect what's necessary, and that's really your first level of security or protection, not to collect data that you don't need in the first place. And then the next question that you would ask yourself is, what is the classification? If the data are private or confidential, then you need the required policies and procedures for security, for accuracy and completeness, and those data should be listed on the data inventory. So some practical tips and considerations. Review your inventory. Is it complete? Is it up to date? And then you can review whether existing security procedures and requirements are sufficient for the data that you are maintaining. Next is training is key. Your entity might have the best policy for ensuring the security of data, but if you are the only one that has read it, it's probably not keeping data secure. So not everyone needs a day-long training or even an hour webinar on data practices or the security of not public data, but it should be periodic. Don't rely solely on the onboarding packet as your only data practices training. On your internal procedures or employees' obligations. If entities get into a situation where employee discipline is appropriate for the mishandling of government data, one of the factors an arbitrator might consider is whether the employee has had proper training. So train early and often to ensure that employees are aware of when their work assignments require access to non-public data, how to administer and maintain non-public data, and where to go when they have questions. You also want to make sure that anytime you make changes to your policies, you are then training your employees and making them aware that your security or internal policies and procedures have changed as well. The next is the data we're maintaining and how it is stored are intertwined. Data practices folks have important information that IT folks need to know when implementing new programs, software, security measures, and IT folks have information that the data practices folks need to know. So if you're a data practices person at your entity who said, I'm not really a tech person, get together with your tech people and share information. Before you get new software, before you create a new database, or before you create a SharePoint site, have a discussion about what data are going to be used, how it is classified, who is going to access it. Those of you listening to this webinar are likely in the best place to flag those issues for your entity, and then IT can determine the type of security to build around those collections. It's always a best practice to determine how data are classified, how they will be secured, and who will have access before you collect the data or implement a new technology or program. Then, as I've said, the legislature is currently in session, considering a whole host of new not public classifications. The Data Practices Office tracks legislation and tries to cover a lot of the data practices provisions. If there are new private or confidential provisions that affect your entity, those will need to go on your inventory, and there will need to be some security procedures put around those data. So as we transition to our breaches discussion, take a moment to consider what kinds of data you interact with, how they're classified, and think about what you are doing to make sure that the not public data are secure. Or even a broader question, do you know what you should be doing? In addition to looking at your inventory, I also encourage you to find an answer to that question this week. So once you know what private and confidential data you have, and you have set your policies and procedures around securing appropriate access, you have to consider what happens when those policies and procedures aren't followed. The data breach requirements are contained in Minnesota Statute Section 13.055. That's listed on this slide for you, and that's the section that we're going to be discussing when we talk about data breaches. So we hear about data breaches in the news, but in the context of the Data Practices Act, a breach of the security of data has a specific definition. It means that a person, and the definition of a person here includes individuals, partnerships, corporations, associations, business trusts, legal representative of an organization. A person views or takes private or confidential data without permission or authority, and that person has the intent to use the data for non-governmental purposes. So I've highlighted private or confidential, just as a reminder that we're only talking about data on individuals, living human beings. And the other important piece is that the data have to be viewed or taken with the specific intent to use it for non-governmental purposes. Anytime there is an intent requirement, I think the determinations can be challenging because you're going to have to look at and determine someone's motivation and investigate what actually happened to the data. And the government entity is really in the best position to assess the circumstances around the breach. Each situation is fact specific, and it may also depend on the security policies and procedures that the entity has in place, which will vary from entity to entity. So we'll go over a few specific scenarios at the end of the webinar to walk through when a breach may have occurred. So if you determine that each of those elements, that definition of that data breach has been satisfied, there has been a breach, then there needs to be an investigation. Sometimes the investigation may start before the determination that there has been a breach to evaluate whether or not that intent piece has been satisfied. When there is a breach, entities need to notify the data subjects whose data were affected by the breach. There needs to be a public report, and if there were more than 1,000 individuals affected, then the entities also have to notify credit reporting companies of the timing, distribution, and content of the notice. So what should your notice look like? It should be in writing and explain that there will be an investigation and public report, and let the data subjects know that they can request a copy of the report and how to do so. In terms of timing, notice should be sent without unreasonable delay. So that's another one of those great amorphous timeframes in the Data Practices Act, like appropriate and prompt. In all things, reasonableness is likely the standard and will depend on the scope and complexity of the breach. So if it is years after you've been made aware of the breach, that's probably not appropriate. Does it need to happen a week after learning of a possible breach? Maybe or maybe not, but there's a lot of variation between those 2 points, and it's going to depend on the specific circumstances and the severity or complexity of the breach that occurred. We do have a sample notice on our website. So if you'd like to take a look at that, the link to our data breach page is listed on this slide here, and that's where the sample data breach notice that we have is available for you. So how must the entity provide notice or send notice to the affected individuals? First class mail will always work, or electronic notice, provided it's consistent with the provisions regarding electronic records and signatures as set forth in United States Code Title 15, Section 7001. I know that's a long cite. That provision is cited in 13.055. It's referenced there for the electronic notice. But what that section generally discusses is individuals consenting to electronic notice. So first class mail or electronic notice. Substitute notice can be used if certain conditions are met. If it would cost $250,000, or there are 500,000 affected data subjects, or there isn't sufficient contact information. Substitute notice could be email if the entity has an email and posted to the entity website and provides notice to major media outlets. So all 3 of those items are required if you use substitute notice. And then, as I mentioned, notice to consumer reporting agencies if there were over 1,000 individuals impacted. Okay, so what information needs to be in your report? So that report that you have to create following that breach investigation. It should include what happened to trigger the investigation, what the results of the investigation were, if there was an employee that access data without a work assignment or for purposes outside of their work assignment. It must include a description of the data at issue, the number of individuals affected, and then if there has been a final disposition of disciplinary action against an employee, then the report must include the employee's name and the discipline imposed against that employee. Entities must also conduct an annual security assessment of any personal information. The assessment is required by Section 13.055, but the definition of personal information is cross-referenced in 325E.61. That citation is on this slide for you, so you don't have to write that down. Personal information is a name plus other identifying information that an entity maintains in an unencrypted format. So unencrypted computer files, paper documents, or other records maintained in a non-computer medium. So data that can't be encrypted. So this might include entities that collect photocopies of individuals' driver's licenses or have paper credit card slips. Theoretically, over time, there may be less and less personal information as we continue to automate and digitize most processes. But right now, government likely has a mix of the format of the records that we maintain. The type and amount of personal information you maintain will determine your security assessment. So note that this requirement is regardless of classification. If you maintain this type of data, then this assessment is required. Finally, many of you know this, but we always like to flag it. For entities who are subject to audit by the Office of the Legislative Auditor, there is a broader reporting requirement. Entities must notify the OLA if not public data, that is data on individuals or data not on individuals, so broader than the data breach, may have been accessed or provided to a person without lawful information. So for this requirement, it's just that there's a possibility that not public data was accessed. So even though there aren't specific Chapter 13 requirements around protecting not public data, not on individuals, it's important that entities put some guardrails up around that data as well, particularly if you're subject to OLA audit, because you will have to report that to that office if there's even an apparent access to not public data. Okay, so we're going to walk through some specific data breach scenarios to discuss when a breach has occurred. So this is scenario number one. At the end of the day, an administrative assistant at the county sees copies at the copier. After glancing at it, they realize that it contains private data about a personnel investigation in another program at the county. They put the copies in the confidential shredding bin. Has there been a breach under 13.055? And does the county have to notify the Office of the Legislative Auditor? Here, there was no intent to use the data for non-governmental purpose. Good faith acquisition by a government employee who disposed of the private data appropriately and did not further disclose or provide access. So there wasn't a data breach under 13.055. There wasn't that intent piece to use it for that non-governmental purpose. They also don't need to report to OLA because the county is not subject to OLA audit. Does that mean that there shouldn't be any corrective action taken? No. This is where training and following up on training and making sure when people print out public data, they go to the copier and make sure they grab it. They don't leave it there for somebody else to access it. But technically there wasn't a 13.055 breach and there was no OLA requirement. Okay, scenario number two. A records technician at a city police department has a work assignment to access the DVS database. When reviewing a file, they note that an adult driver's license photo looks like someone they work with. The tech calls the coworker over to look at the photo. Has there been a 13.055 breach? Does the city have to notify OLA? Here, that records technician, they did have a work assignment to use the database, but then they called their coworker over because they thought that the photograph looked like one of their coworkers. So the initial employee had a work assignment, but it was used inappropriately because they called over another employee who didn't have a work assignment to use for a personal reason, just because they wanted to discuss the way that somebody looked in that driver's license photo for personal, non-governmental reasons. So there was a breach, a 13.055 breach here, but there is no reporting to OLA because the city is not subject to OLA audit. Okay, our third scenario here, Black Hat 13 has hacked into an entity's staffing record system. They have accessed all of the files, including private personnel data. Has there been a 13.055 breach? Does the entity have to notify the Office of the Legislative Auditor? A hacker can't have governmental purpose to access data. So if a hacker accesses private or confidential data, a breach has occurred. There was intent to use the data for non-government purpose. Here it was private data on individuals. Here we don't know what type of entity it was. If it was a state agency or entity subject to OLA authority, then they have to do report to OLA because not public data was accessed. Okay, scenario number 4, an employee at a state licensing board took a copy of test questions and scoring key of the licensing examination home and showed it to their roommate. Has there been a breach under 13.055? Does the school district have to notify the Office of the Legislative Auditor or the licensing board? Here, 13.055 don't apply to data not on individuals. So we have test questions and scoring keys here, but that's not data about a person or a living human being. It's just data not on individuals. And although they are non-public data under 13.34, they are not data on individuals, so there's no 13.055 breach. However, the board is subject to OLA audit and will need to report to OLA because not public data, even data not on individuals, may have been accessed by somebody without a work assignment. So, of course, just because there's not a breach under 13.055, it doesn't mean that the entity shouldn't do anything in response. Some corrective action is appropriate to figure out how and why this happened and to make sure it doesn't happen again. So again, even though we don't have security requirements around data on individuals, having some sort of internal procedures that employees are trained on will help limit opportunities for this type of data to be disclosed and set entities up for success. Okay, so that is our presentation and scenario session today. Let's take a look at some of your questions. Remember to send them to all panelists so we can make sure to see them. A few reminders on the slide. The slide deck is available on our website and you can access the recording on our YouTube page in the next day or so. I'm also putting the evaluation in the polling panel. If you please fill that out and take a look and let us know how we did and any other topics you'd like to see in the future. So I'm going to open that poll and I'm also going to reshare the PowerPoint while we are going through your questions. Thank you.
Okay, and if you don't hear us for a little bit, we are looking at the questions and making sure that we have the right information. So if you do hear some silence, that's okay. We are just reviewing your questions. But the first question here is, where does the intent requirement come from? Is this referring to the good faith acquisition provision in subdivision 1A or something else? The intent requirements are contained in 13.055 subdivision 1. And when looking at the definitions under there, you do have to kind of piece it together a little bit because there's a definition for breach of the security of the data. There's also a definition for unauthorized acquisition and unauthorized person. And so you do need to look at the entire definition to kind of understand when a breach would be. But that good faith acquisition provision is contained in subdivision 1A, and it does note in there that good faith acquisition of or access to government data by an employee, contractor, or agent of a government entity for the purposes of the entity is not a breach of the security of the data if the government data was not provided to or viewable by an unauthorized person or access for purposes not authorized under 13.05 subdivision 5. And so, yeah, so when you're looking at that good faith acquisition, that kind of exception when there's not a breach, that is going to be under subdivision 1A.
Casey, and I'll just chime in here. If you look at 13055 subdivision 1C, that also references in those definitions the intent component as well as part of assessing whether or not there is a breach. So that intent for the non-governmental purposes is also referenced in subdivision 1C.
Okay, we are still waiting for your questions, and so if you do have them, please send them to all panelists in the Q&A panel. We did have one earlier question here too about not seeing the pop-up for the PowerPoint, whether it was possible to repost or resend. I know Katie did kind of have the pop-up again. We know some folks aren't able to see that sometimes. It really depends every now and then. But if you do go back to the webpage where you signed up for the webinar on the DPO website, you can find the slides under other data practices and OML guidance webinars in a section that you kind of hit the tab and it opens up and you can find the slides on there. And then we will repost the slides or a video of the webinar on our YouTube page. So you can certainly find a copy of it there too.
So we have a question here about social security numbers, saying that certain business licenses require social security numbers on applications. They're maintained in a database. It sounds like a secure database at the entity. Those with a work assignment that requires access can access the database, but it sounds like other departments may be able to use the database that also has those social security numbers in it. The question is whether that's appropriate. So social security numbers are private data under the Data Practices Act. Even partial security numbers are classified as private. They're also protected under federal law. If you have private data and social security numbers are especially sensitive, this is something that you'd likely want to make sure that you have adequate safeguards around, so only those with a work assignment are able to access that data. So whether it's password protecting certain portions of your database or having some sort of limitations so that way only those who need it for their work can access it, that would be appropriate. The question asks whether it's a data breach to have to not have those security provisions. I wouldn't say that it's a data breach unless somebody accesses it with a non-governmental purpose, but you might not be meeting your requirements to adequately secure that private data about individuals. And you're opening yourself up for the possibility of a breach if somebody does access it for a non-governmental purpose.
Okay, we have another question here. Does the notification of a breach under Minnesota Statute 13055 relate to a right as defined by Minnesota Statute 1310 that would pass on to a representative of the decedent if the data subject of the breach data is deceased at the time the breach is discovered? Yeah, that's an interesting question. So under 1310, which is the provision about data on decedents, really the rights or for individual data subjects are transferred to a representative of the decedent upon their passing. So the representative essentially exercises these rights that the data subject would otherwise have or would have should they be alive. So under 13055, a notice to individuals is required, and I would consider that a right for the individual data subject. The data subject has a right to be notified when their private or confidential data is breached. So the entity should reach out and provide that notice to the representative to the representative of the decedent, excuse me, under Minnesota Statutes 1310.
Yeah, and we do have a follow-up question that's similar. If an employee has unlawfully accessed an individual's data and the agency learns this individual has been deceased for some time, would this no longer be data on an individual? It would be data on decedents under 13.10. And so you would still want to maybe consider that because there's still potential harm there if data are used improperly, even though the individuals are now deceased. An additional question that we have here is, do you have any more complex examples, perhaps mixing public and private data and determining what is public and private and what was breached? That's a great question. And the challenge with data breaches is that they're always unique, right? And so, trying to dive into really complex examples is a bit challenging for us. But what we can say on that, so we don't have any more complex examples that we can provide you with today. But if you do find yourself in a situation where you think you have had a data breach under 13.055, certainly reach out to our office. We are happy to chat with you and kind of discuss some of the dimensions that you need to consider. We can't make a lot of decisions or tell you exactly whether a data breach has occurred. We'll encourage you to chat with your entity's legal counsel on some of those issues, but we can certainly help you walk through those considerations. And so anytime you do have questions involving a breach, certainly reach out to us. Don't hesitate to do that. We are happy to help you think through each of those situations when they hopefully rarely occur.
Another question here. If an individual whose data was breached lives in a state other than Minnesota, are there additional notification requirements beyond what's in 13.055? As in, do you have to look at the statute of the state where the individual lives and follow those statutory notification requirements as well? So we're Minnesota government entities and we're subject to Minnesota law. Unless there's some sort of federal provision that supersedes our law, we're subject to the Data Practices Act. And so you have to follow the requirements in 13.055. There might be other states that require things of their government entities, but you are responsible for following the Data Practices Act.
Okay, I have another question here. So where can you find the guidance around appropriate destruction of data held by a government entity when it is no longer needed? Yeah, good question. So if you have data that has met the end of its retention requirement, or maybe you don't need to retain it anymore, it's not on your retention schedule, and you want to properly destroy it to ensure that you're destroying that private or confidential or non-public data. The Data Practices Act doesn't have, specific technical requirements for destroying this data properly. You maybe want to speak to your IT staff to see what would be the most appropriate method for destroying this data. If you are IT staff and you're looking for that guidance, I would maybe suggest reaching out to the staff at the Minnesota State Archives, who can provide some guidance on records management, and that would include records destruction, and they would have information on destroying electronic information as well.
Just a quick follow-up to that one. In 13.05 subdivision 5, it does say that sort of the data must be destroyed in a way that prevents its contents from being determined. So obviously it's really going to depend on what format the data is in, or what the format the data are in, and how it can be disposed of. So that's another one of those kind of, it depends, but basically it needs to be in a manner where its contents cannot be determined.
We are at our time for today. Thank you all for attending and sending us in your questions. If we didn't get to your question, we will follow up with you. If you haven't already signed up for government delivery notices, we'll send out notifications for future workshops and webinars. So be sure to sign up there. We also have a new rulemaking listserv on our website that you can sign up for, as well as we start a new rulemaking update project. So see our website for that. It's on the top navigation bar on our website, and you can sign up for updates specific to rulemaking there. Thank you for joining us today, and have a great day.